Okay, good afternoon, ladies and gentlemen. Welcome to Dr. Olu Asekun live podcast. Thank you for joining us. Wherever you may be, please invite your friends, family, colleagues, and join us as we proceed with our weekly live podcast. Thank you for joining. This is the time to invite your friends, family, and colleagues so that if you have questions, you start early so that you stand a chance of getting your questions answered within the hour. So, as usual, we will go through the updates. Subsequently, we will go into questions and answers. So there is not a whole lot between last week and now, between last week, Wednesday, and now. However, we are going to be talking about some updates and some trends. The first thing I want to say for those who are listening to us is that according to American Immigration Lawyers Association, AILA, they notify us to advise our clients if you are reporting to ICE, you should continue to check in, even though DHS is currently shut down. But for those who are reporting, the shutdown should not be an excuse so as to avoid your arrest. So, if you are reporting to ICE, continue to check in so that there is no problem. Even though DHS is currently shut down, but you should continue to report. You should continue to check in if you are reporting to ICE. So that is the first information they told us to share with our clients. And because my listeners too, they have the opportunity to benefit from this information. So that is why I'm sharing it. The second message from AILA, American Immigration Lawyers Association, this morning is also to warn about the very alarming rate of scams. They advise us to warn our clients that immigration scam is on the rise right now, that scammers are using Facebook, WhatsApp, and even AI. In some cases, they use paid adverts to deceive innocent people. Please be careful and verify information circulating on social media before paying anyone, before parting with your money. One thing I want to warn my listeners about, especially, is the use of AI. There are so many AI-generated videos that are circulating on social media, circulating false information, circulating scary information, circulating, in some cases, fake information with the intent of depriving people of some funds. For example, there was an AI-generated video that was circulating that was saying that that Trump administration is going to stop dual citizenship in February. All those things are fake. Is there any problem? Are you sure people? Everybody just disappeared from here. Let me see. No, all the people that I see before, everybody just disappeared. Are you sure nothing is going on? No, this is it. So people can hear us? Yeah. Okay. Okay, just making sure, just because it just disappeared. Oh, okay. Okay, maybe I didn't open it correctly. Yeah, so as I was saying, beware of all these fake news, especially AI-generated videos. If an immigration information is legit, why can't the producer or the lawyer or whoever is sharing the information, why can't the person show his face the way I'm doing now? Why hide under AI to scare people, to scam people? So we have been advised to warn our client, and in this case, our listeners, that scammers are really, really on the rise right now, using all kinds of methods, even including advertising. They advertise fake news. They pay for advert on social media so as to get people's attention. A lot of fake information are ongoing. Please, before you pay anyone, verify your information and be sure that the information you are getting is the right one before you part with your money. Scammers are on the rise. Okay. The next thing I want to talk about is that on February 9, the Ninth Circuit Court of Appeal gave the DHS the green light to proceed with the termination of TPS for Nepal, Nicaragua, and Honduras. You will recall that a federal judge previously halted this termination of TPS, but now the Ninth Circuit Court of Appeal has given the DHS the green light to proceed with the termination of TPS for Nepal, Nicaragua, and Honduras. Also, on February 13th, the DHS announced the upcoming termination of TPS for Yemen. So if you are from Yemen, TPS is going to be terminated for Yemen. Usually, the termination will take effect 60 days from the date it is published in the Federal Register. It is yet to be published in the Federal Register. We are getting advanced information. That is why we are sharing it. But once they publish it in the Federal Register, 60 days from that day, it will be effective. The next thing I want to talk about is that the True American Immigration Lawyers Association, they release case processing trend since the Trump second administration. In other words, between January 20, 2025 to December, so they gave us the trend of how USCIS is adjudicating H-1B, L-1, O-1, EB-1A, and EB2 national interest waiver. So according to the statistics that was released, for H-1B, there is really no change in the processing approval rating. Adjudication cases remain 98% for H-1B, so there is no change. However, for L1, there is a 3% reduction in the approval rating for L1. For O1, there is 10% reduction in the approval rating. 10% reduction in the approval rating. And of course, for EB1, there is a 24% reduction in the approval rating for EB1 in 2025. So for EB2, national interest waiver, there is a 25% reduction in the approval rating. So it means that for every 4 applications, they deny 1. So 1/4 of all the applications that were filed in 2025 were denied by USCIS, according to these statistics that were provided to us by American Immigration Lawyers Association. Of course, it was carried out by a research company, but it was published and provided to us by American Immigration Lawyers Association. That is the update we want to talk about today. I believe that you should be ready for questions right now. So, going into questions, the first question we have today. Good day, doctor and team. Good day. Thanks for all your help. May God reward you for all you do. Amen. Please, how long does it take to get a response from USCIS after acknowledging receipt of RFE? Well, under normal circumstances, it takes 60 to 90 days after USCIS receive a response to an RFE before a decision is taken. However, that may not be applicable in this case if this person is from one of the visa what now? Those who are suspended. Yeah, visa banned countries. Thank you. So if you are from one of the visa banned countries, so they may not take a decision within 90. Normally, it is supposed to be 60 to 90 days. But if you are from one of the visa banned countries, they are not taking any decision. And let me say this. We just noticed a trend. In fact, a client called me yesterday to find out if we have been receiving approval of employment authorization from travel ban countries. Before yesterday, I didn't pay attention to it because we continue to get approvals and we continue to receive employment authorization. But when that person asked me the question, we now started looking into it and we realized that we have actually not received any employment authorization for anyone from travel ban countries since this thing came into effect. All the employment authorizations that we are getting, all the approvals we are getting, they are actually from other countries, not from travel ban countries. So when we paid attention to it yesterday and we started looking at it, we realized that all the employment authorization that we have been receiving, they are actually not from travel ban countries. So what that suggests, because we have employment authorizations that were approved in December for travel ban country clients. Now, we now realize that we are yet, today is February 18, and up till now, we are yet to receive the physical card for those clients that are from travel ban countries. So what that tells me is that this pause is affecting everything relating to travel ban countries. Even those who attended visa interviews, immigrant visa interviews abroad, they are not issuing them immigrant visas right now from travel ban countries. They are telling them that everything is okay, but they should wait until the ban is lifted. So the only difference that I've seen so far from travel ban countries are those clients who are in removal proceedings. So the reliefs that were granted in court by immigration judges, those ones does not affect travel ban countries because, as I said, we have clients from Nigeria and we were still able to get green card for them in court at the immigration court this year. Even as recently as last week, I was able to get green card for a couple of clients from Nigeria in court. Now, whether they get the physical green card or not, the moment the immigration judge grants an order that this person, the application for adjustment of status is approved, that person becomes a permanent resident. It does not matter whether the green card has been produced or not. So even if the pause affected the production of the green card, it will not affect the person's eligibility as a permanent resident. It will not affect that person as a permanent resident. That person is already a permanent resident. So if the green card is delayed, all you need to do is to schedule an InfoPass appointment with USCIS, go with the court order and a valid passport, and then they will stamp your passport to reflect that you are now a legal permanent resident. But we have noticed that the physical cards are being delayed for people who are from travel ban countries. So I just want to put that out there. So next question, please. Good morning, sir. My wife is the main petitioner of our asylum case. It has been approved and we have our green card for the past 4 years. Is it safe for me to travel to Nigeria to see my sick parent? Is there a continuation? Okay. Well, you see, this question is very, very important, and you have to be careful because this is a catch-22 situation. If you presented a case to show that if you travel to Nigeria, your life will be in danger, you will be killed. If your asylum application is approved and then you are given green card, and then the next thing you are planning of going to Nigeria, I will not advise it. I will not advise it because it can impact your citizenship later. Because I'm sure, even though your wife is the principal, I don't know the details of your case, I don't know what you presented, but from my experience as an immigration attorney who has litigated asylum cases at the immigration court several times, I know what you need to prove in order to get an asylum approved. I know that you have to prove that your life has been in danger or your life is going to be in danger. You need to prove that you have either suffered past persecution or you have a fear of future persecution from the government of your country or from someone that the government is unwilling or unable to control. So now, if your wife presented this case and she was granted asylum, because you are also a derivative in it, but like I said, I don't know the story you presented. I'm just giving this answer based on the requirement of asylum that I know. I know that it is likely that your wife will have painted a picture of both of your life being in danger. Because if your wife's life is in danger and you are not affected, I'm not sure they will approve the asylum. Again, I'm just basing this on the general information on the eligibility for asylum. I'm not basing it on your specific situation. But I do know that if you are granted asylum on the basis that your life will be in danger or your wife's life will be in danger if you go to Nigeria, if you are now granted green card and you are now thinking of going to Nigeria to go and visit your parents, I don't think it's a smart move. There are some things that I cannot say on air, but if you call the office, if you call our office, I may be able to talk to you on how to handle the situation. But there are certain things that I cannot say on here. Or suffice to say here that it is not a smart move for you to return to Nigeria if you are granted asylum, at least until you become a citizen. When you get your citizenship, yes, it will not matter at that time because there could be changed country condition. The whatever it is that was creating danger for you may have been removed. But if you are still a permanent resident, when you are going to apply for citizenship, you are going to have to list all the countries that you have traveled to since you got your green card. And the moment you list Nigeria, as one of those countries, I can tell you, especially based on the trend of this current administration, it will definitely be an issue. It will definitely be an issue. So it is not advisable that you do it. But if you call the office, we may have one or two information to provide to you. Next question, please. Okay. Is it true that only 29 days are given to Nigerians at the border? No. That is not true. That is far from the truth. I know people who came in and were given 6 months, who have their visa and were given 6 months. I have a friend who visited recently and was given 6 months, even though she only spent 2 weeks, but she was given 6 months. So it's not a blanket thing. Yes, some people may have been given 29 days, but it's not a blanket 29 days for everybody. No. Especially if you previously have your visa. But if you just recently obtained your visa, U.S. policy in terms of visa issuance to Nigerians have changed, and you can now you can only get a visa that is valid for 90 days. And of course, at the port of entry, you may be granted admission for only 30 days or 29 days, as you stated. But for those who already have their visa, I know people who already have their 5-year visa and they continue to use it and they still get 6 months, even at the port of entry. Next question. Good afternoon, Dr. Olu. God richly bless you and your team for serving humanity. Amen. Thank you. Amen. Please, if someone decides to do paper filing for adjustment of status, what is the required form to fill in order to make payment to USCIS? Okay. Is it G? What is that form called? G? 1435, I think. Let me confirm it. Yeah. It's G 1450, 1450. Okay. The form is Form G 1450. Form G14, G as in government, 1450, G 1450. Okay, move to the next question. Hello, sir. Mom was scheduled for oath ceremony on December 18, 2026, and it was cancelled. What next step can we take since we haven't heard from USCI? She's from Nigeria. Yes, it was cancelled because of the pause. It's affecting everything across the board. So until the pause is lifted, there's really nothing for her to do. Once immigration comes up with new policy, if any, if they decide to come up with new policy, they can only do one of two things. They can either invite her back for another round of interview, or they can just proceed with the swearing in, since she has already passed the citizenship test and all of that. So it depends on what they come up with after the pause is lifted. But for now, on her part, there is really nothing she can do other than just to wait. Next question, please. Good day, sir. Is there any development over the $100 that immigrants were asked to pay? What is the new? I think they've started collecting it again. They have resumed. They have resumed the collection of that fee. But again, you have to wait for letter. Don't just pay it. If you receive a letter to pay it, then you go ahead and pay it. But they before court, they have to do it. What? For court, they don't get the letter. Only when they have the application. Yes. Yeah. Okay. Thank you for the clarification. Yes, if your case is pending with USCIS, you will get a letter to pay it. So once you get the letter, you pay it. However, if you have an asylum that is pending at the court, at the immigration court, you are not going to get any letter. The court is not going to send a letter to you, but you can go ahead and pay it. But they have resumed the payment right now. Yeah, that's a good question. That's something that I should have mentioned at the beginning. Yes, they have resumed the payment of the $100 fee. Remember that they were sent these letters before
So they can use that same letter that they received before to pay it.
Okay. If you receive a letter before to pay it, before it was paused, you can still use that letter because USCIS may not send you a new letter. So you may use the previous letter to pay it now that they have resumed the payment of the fee. Next question, please. Doctor and team, blessed day to you all. Thank you. Thank you too. Thank you. Okay, that person didn't ask question. Okay.
Let me see. No, sir.
Okay. Thank you. Next question. Good evening, sir. God bless you and your team. Amen. Sir, I'm still awaiting an interview date from NVC. Is there any hope? Well, yes, you should be getting an interview. The pause or the visa ban does not affect that. They are still scheduling people for interview and they are still conducting interview. I mean, we have clients in our office here, even from Nigeria, who received notice of interview. We received notice of interview last week. We still continue to receive interview date. They are still processing it. They are just not issuing visa right now. So, yes, there is hope. You will still get it. You will still get the interview date. Remember, this visa ban is for initial 180 days, which is only 6 months. So, I'm sure that by June, they will review it, and then many of the countries may come up the list. And if they don't, then they will let us know how to proceed at that time. But for now, the NVC is still processing applications. They are still processing the immigrant visa packages, and they are still scheduling people for interview. Okay, next question. I applied for N600 for my 2 minor kids, June 2025. Fingerprints done. The 16-year-old oath ceremony done, but the 10-year-old application still show in process, still September 2025. What's your advice? Well, I don't think the visa ban should affect N600 because N600 applicants are already US citizens. So this one is not an issue of visa ban. The only thing you should check is the processing time. If it is still within processing time, can you please help me check the processing time for N600? If it is still within processing time, then all you need to do is to wait. But if it is outside processing time, then you can do a service request, you can use congressional intervention, or you can even call USCIS, even though it is almost difficult to get any live agent on the phone. It is AI that answers most of the calls now. So, but this one is not affected by the pause or the visa waiver, visa ban, because N600 applicants, they are already US citizens. So this is not one of those things that are affected by visa ban. So if it is outside the processing time, then you should do a service request. But if it is still within processing time, then you have to wait until it gets to that. But this is not one of those things that is affected by a travel ban.
I don't know where this person is, but let's just base it on Dallas.
Okay.
The current processing time is 6 months.
Okay. Well, depending on your location, so you have to use your location to check the processing time. But the one we just checked right now is for Dallas. If you are in Dallas, the processing time is 6 months. So if it is less than 6 months, then it is still within processing time. If it is already more than 6 months, then you can do a service request and then wait for the outcome of the service request. But this is not one of those things that is affected by travel ban or pause.
No, I don't know if the second child was issued an RFE. We just got one approved recently, one in 600. She has been called for an oath ceremony, but they issued an RFE, so that application took almost a year after they reviewed the RFE.
Okay. Well, as I said before, this one is not affected by travel ban. So they just called my attention here that even in our office, we just got an approval of N600. I already know that It doesn't affect a travel ban does not affect it. However, what I was just told here now, reminded, is that if USCIS issued an RFE, request for evidence, then it may take longer. Even if the processing time says 6 months, it may still take longer if they issue an RFE, because when you respond to the RFE, they will now review it depending on what the issue is. If it is something that requires additional review or investigation, all those things can affect the processing. But generally, N600 is not affected by either the pause or travel ban. So, next question. Hello, Doc. I have a pending EB2 NIW, and I also have an interview for asylum next month. Should I file for I-485 for the pending application EB2 NIW? Is that a continuation, or that is the only question? Okay. Now, since go back to the question. Okay, since the NIW, the EB2 NIW has not been approved, I will not suggest that you file adjustment application right now. I mean, the only benefit of filing adjustment application right now will have been for you to get employment authorization. But because you also have a pending asylum application, that is something that will give you an alternative way of getting employment authorization. So I will just wait and see the outcome of the EB2 NIW before you think of filing adjustment of status. So just wait and see. At least if you are eligible for adjustment, okay, let me review my answer to that question, because there is something here. Because you also have a pending application for asylum, you still have to determine whether you are eligible for adjustment of status or not, because you may have been out of status. That is something that I cannot determine from the fact of this question. So if, for example, you are still maintaining legal status, you may, if applying for adjustment of status will keep your legal status, yes, that is something that you may want to do in order to preserve your eligibility for adjustment. But if you are already out of status and you are not eligible for adjustment of status, whether you file it now or you file it later, it will really be immaterial, because employment-based application, for every applicant for employment-based application, they must be maintaining legal status at all times. So the asylum exception only applies if you file your asylum application while you are maintaining legal status before the expiration of your I-94. But remember, that is something that this administration, they are trying to argue that is no longer the case. That is one of the reasons we filed a lawsuit in the district court in Florida, Middle District of Florida, to challenge USCIS over this matter. So I don't know whether this is where you fall into or not. But even if that is your case, applying for adjustment of status now will not change it. If you file your asylum application before the expiration of your I-94, if that is the basis of your eligibility for adjustment of status, whether you apply now or you wait until the EB2 NIW is approved, it will not make any difference. And my advice will remain that you wait and determine that it is approved before you go into adjustment, so as to avoid wasting some money. Next question, please. Okay. Well done, sir. Please, how does foreign state of chargeability work for someone waiting for immigration interview in country of residence, not country of birth? EB applications. Well, there are multiple issues here, because it is possible that an applicant may be...
Sorry, there's a second question for him. Or maybe a supplement.
Okay, that's a continuation of the question.
Yes.
Okay. My place of interview place shows UK, but foreign state of chargeability shows Nigeria. Yes, that's what I was going to explain. There are multiple issues here. It is possible for somebody to be dual citizen of multiple countries. So in which case, let's say you are a citizen of Nigeria, you are also a British citizen. I mean, using this fact that you presented. Now, in your application, you are the one that will determine which of the citizenship you want to use for the purpose of applying for immigrant visa. If you choose to use the Nigerian citizenship, it does not matter whether your interview is conducted in the UK or not. They will still look at your eligibility, visa availability under Nigeria. Incidentally, both Nigeria and the UK, they fall into the same category for the purpose of determining immigrant visa chargeability. They fall into the same category. But in some cases, it is possible for you to be a citizen of Nigeria and a resident of the UK, in which case, even though you are legally in the UK, you may be a, what do they call permanent resident in the UK? You may have indefinite leave in the UK. But because you are not a citizen of the UK, they will not charge you under visa classification under UK. So they will still charge you under Nigeria. So it is possible for somebody to have the ability to be charged in multiple countries, in which case you determine which of the countries you want to use. It is also possible that you can only be charged in one country, but your visa interview can be conducted in another country. So even if visa is current in the country where you reside, because your country of citizenship is where the visa is charged to, you will still not be able to get the immigrant visa until visa is current in your country of nationality. So, but where you are a citizen of multiple countries, then you will have to make a selection where you want to be charged. But like I said, in this example, both UK and Nigeria, they are under the same category for the purpose of chargeability for immigrant visas. But of course, that is on the visa bulletin. But individual countries may still have, there may still be differences in the micro individual countries. Those informations are not available to us. The only one that is available to the public is the general one. But under the general one, both the UK and Nigeria, they fall under the general one. There are only about 3 or 4 countries that are treated separately, especially for employment based. Those countries are India, China, and I think Philippines. No, Mexico is not charged separately for employment based. It's only charged for family based. This is employment based. So it's India, China, Philippines. I think that's about it. I don't think Mexico is charged separately for family based. Yeah, not for employment based. So next question. Good day, sir. Are they still processing adjustment of status application for Nigerians in the US now? I'm planning on filing my wife's application. Yes, they are still processing it. They will accept your application. They will invite you for fingerprinting. They will continue processing it. The only thing they will not do is to issue a decision. They will not issue a decision until the pause is either lifted or the travel ban is lifted. So until that time, but yeah, go ahead and file it, because if you submit the application for adjustment of status for your wife, whether they process it, whether they approve it or not, at least once it is filed, it will keep your wife in legal status. Once you have the receipt notice for the I-485, that will be a valid evidence of legal status. So for that reason, go ahead and file it. In addition, even though there may be a pause now, whenever they reopen it, whenever they resume processing, they will start from those who are already on the queue. So they are not going to start from those who are just filing. So it is advantageous for you to file it now. Next question. Good day, sir. I'm based in the US, but my spouse is not. We got married in Nigeria, court and traditional. Is it mandatory for a divorce to be done in the same state the marriage was conducted? No. For the purpose of divorce, divorce can only be done in the place where you reside. If both of you are not residing in the same place, it can be done either where you are residing or where your spouse is residing. However, that would depend on who is the petitioner. For example, if you are residing in the US and your spouse is residing in Nigeria according to your fact, you as a petitioner cannot file your divorce in Nigeria because you don't live in Nigeria. So you may still be able to, the Nigerian court will have jurisdiction over your wife, but may not have jurisdiction over you. It's not that really straightforward, because if you have properties in the US, for example, the Nigerian court will not have jurisdiction over your property in the US. If, on the other hand, if you file in the US and you have properties in Nigeria, or your spouse have properties in Nigeria, the American court will not have jurisdiction over your properties in Nigeria. So in this case, the best thing, it depends on who is going to be the petitioner. So if you are going to be the petitioner, you file your divorce here and then register it at the Nigerian court. But if you don't live in Nigeria and you file your divorce in Nigeria, if I'm the lawyer representing your wife, I will challenge the jurisdiction of the court. The same thing, if your wife does not live in the US and attempt to file divorce here in the US court will not have jurisdiction, even though you live here, because she is the petitioner, because it is the petitioner that is required to establish jurisdiction. Divorce is a little different from real estate litigation. For real estate, it is where the property is located. That is the jurisdiction that we control. But for divorce, it is where the petitioner lives. If you live in the US and you go and file a divorce in Nigeria, if I'm the one representing your wife, I will challenge the jurisdiction of the Nigerian court, because you don't live there and you are supposed to reside in Nigeria before you can approach Nigerian court. And your wife is supposed to reside in the US before she can approach an American court. But of course, you can file it here and register it in Nigeria. It can be filed in Nigeria and register in the US. Next question, please. Good afternoon, Doc. I mailed my work authorization, green card, and travel parole request as VAWA applicant to one of the USCIS offices in September 2025. Till now, I have not received any acknowledgement. Well, you may not receive it because you may have filed it at the wrong location. And besides, the anything relating to VAWA is taking unprecedented, there is unprecedented delay right now in getting receipt notice, anything relating to VAWA. Even the VAWA application itself, the I-360, the receipt notice sometimes is taking more than 6 months. We have seen situations where we filed something in March and we did not get the receipt until December.
Right now we haven't received some of the ones that were filed in May.
Aha. So they are also just calling my attention now that we have applications that we filed since May and we are yet to receive receipt notice. So anything relating to VAWA. If you have been listening to our podcast, you will realize that I can't remember precisely, but some weeks back, I mentioned something about VAWA, that the USCIS just realized that there is an unprecedented surge in the number of applications, number of people applying for VAWA. In some categories, the percentage of increase was up to 2,000%. And of course, that was alarming. So I don't know what USCIS is doing about it, but I know that since they announced that thing, it has been causing a lot of delay. And I'm sure they are probably reviewing all the applications that are incoming. That is the only thing I can suspect. But it is not peculiar to you. It is taking much, much longer right now, assuming that you file it at the correct location. Next question. Okay. Hello, Dr. Asekun. Good day, sir. Please, sir, any update on Nigerian ban? And please, sir, is the ban also for Nigerians here? Thank you, sir, and God bless you for all you and your team do. Thank you, sir. Oh, yes, thank you. There is no update right now, and yes, it affects people who are here too. And it is not only Nigeria. All the 75, is it 75? Yeah, all the 75 countries that were listed on the travel ban, yes, every one of them is impacted. And when the travel ban was originally announced, they said that the presidential proclamation stated that they will revisit it in 180 days time. 180 days is 6 months. And since it started, I think it was issued in December to be effective January 1st. So since it started January 1st, 180 days is going to be June. So before anything can change, it's going to be June. But of course, if anything changes before then, we will update you. But for now, we are looking at June before there can be any changes. Now, the travel ban should not be confused with the pause. The pause is different. As far as the pause is concerned, that one is only for 90 days. They are pausing it for 90 days to let USCIS come up with a more robust way of adjudicating these applications. So for the pause, that one is only 90 days. So 90 days from January, that will be March. So by the end of March, I'm sure that they will resume the pause. But as far as the travel ban is concerned, that one is 180 days. Next question. My O1 visa was just approved. I used my approval petition to apply for a renewal of my driver license at the DPS, but they said they have to send a copy of the approval to the DHS and USCIS for verification. It's been about a month now and I haven't gotten anything in the mail. Should I be worried, and what should I do next? Well, you should just follow up with the DPS. Okay, thank you, attorney, and God bless your work. As an O1 holder, do I qualify to apply for EB1A when the pause is lifted? Well, as for what you can do, you need to go back to the DPS for a follow-up. I mean, sometimes it may take a follow-up for USCIS to respond. I've seen a situation where USCIS did not respond until the DPS contacted them the second time. So just follow it up, and then I believe they should respond. Now, as for EB1A, well, if you meet the requirement, you can apply. But I want to tell you that EB1A is slightly, not a whole lot, but slightly different from O1. Both of them are alien of extraordinary ability. But the difference is that for O visa holder, because you are going to use a sponsor, because you have an employer who is sponsoring you, the scrutiny is not as high as EB1A. Because as for EB1A, you don't even need a sponsor. You don't need an employer. It is self-petition. You can self-petition, but the only thing you need to show you is that you are one of the top 5% of your own profession. You have attained the pinnacle of your career. For O1, the standard is slightly lower than EB1A. And like I said, primarily because an employer is the one sponsoring you, and it is the employer that will present all the information, why they needed your services, how much they are going to pay you, and all of that. That is not required for EB1, because as I said, USCIS is still accepting application. So if you are eligible, you can go ahead and submit the I-140 petition, and then whenever they resume processing, they will then either approve or take adjudicative action on the case. So that is all about it. So the next question. Good day, sir. Will USCIS receiving my R1 petition the 6th? No. Will USCIS receiving my R1 petition the 6th, a day after I-94 expired? Okay, a day after I-94 expired 5th, affect me in any way? Is there any hope of Congress restating the R1 non-ministerial visa? Oh, yes. Yes to both questions. Now, one day late may be waived, but it is not going to be automatically waived. The employer will still have to explain why it was one day late and request that USCIS should waive it. USCIS can waive it in the exercise of discretion, but it is not automatic. It is something, in fact, the employer may apply that they waive the 1 day lateness and USCIS may decline. I've seen both scenarios before, especially during COVID. I've seen cases where we had to file more than 2 weeks late and we were still able to appeal to USCIS, explain why the application was late, and USCIS still went ahead to approve it. And we have also seen a situation where it was 1 day late and USCIS still deny it. So it is still a discretionary matter, and the applicant, the petitioner, still have to apply and request that the lateness be waived. It does not matter that it is only 1 day. They still have to request it. Go to the next one, please. Part 2. Oh, I think part of the part 1 is also talking about the reinstatement of the ministerial. Yeah, I believe they are going to extend it. To be honest, I've not even checked lately. Do we have any information about non-ministerial R1 non-minister, whether it's been extended or not? I've not checked lately. Okay, we will check before the end of the program, and we will let you know. Because I know that they passed something recently where they removed the one from DHS. But in the meantime, let me read the part 2 so that I can be answering that while you are looking at it. Okay, part 2. How long will it take? Can I withdraw my application? And what is the implication on my immigration history? I'm from one of the bank countries. What's your advice? Oh, okay, this is still asking whether the R1 should be withdrawn. Well, whether you withdraw it or not, I don't think it will have anything to do with your status, because if your status expired on the 5th, so whether you withdraw the R1, that is not going to change it. It means you are still going to be out of status. So since the application has already been filed, I would rather just wait. One thing I know is that USCIS will not deny it until they issue a request for evidence and ask you to provide evidence that you have been maintaining legal status since your entry. At that stage, the employer, in responding to the RFE, can explain the reason for the delay and request that USCIS waive the 1-day lateness. But again, they have to ask.
I think they extended it until September.
Okay, yeah, for the R1 non-minister, yes, it was extended on February 3rd. It was extended until September 30, 2026. So it was extended until the end of fiscal year 2026. Yeah, I know that when they signed something in February, it was part of it. Yes, it was extended temporarily until the end of fiscal year 2026, which is going to be 30th September 2026. So yes, if the R1 is approvable, they will still approve it because the non-minister category has been temporarily extended. Okay, next question. Good afternoon, sir. Please, I'm a Nigerian with a pending VAWA case. My prima facie is to expire on February 25th, but I have not received a renewed copy. What should I do? Lately, they have been delaying issuing extension of the prima facie cases, prima facie letters. We also have situations where the prima facie has expired and we have contacted them requesting an extension of the prima facie determination. We are yet to receive the extension. I cannot say for sure right now whether the pause is the one affecting it or it is just other administrative issues. But all I can tell you is that you are not alone. We have similar situation in this office where the prima facie has expired. It has not been extended on their own. We have requested for an extension and we are still waiting. We are yet to receive anything. So you are not alone. It is what is going on right now. Okay, next question. Please help me. I'm Nigerian with marriage-based LPR. I was wondering if joining Army Reserve will expedite my naturalization. Well, this is a question that I really don't have the answer to right now. I know a couple of people who have told me, but I am yet to verify. So I'm not able to tell you yes or no. But I know a few people who have told me that the ban, the military, the US military is currently not accepting citizens of travel ban countries. Multiple people have told me, but again, I've not verified it. In fact, I promised I was going to check it out, but I've not been able to. I'm not going to give you information that I'm not certain about on this platform. So it is not something that I've verified, but I heard that the military is currently not admitting people who are from the travel ban countries, but I've not verified it. Please remind me. I want to check. I want to verify it. I was going to contact some recruiters to find out, but I just I've been busy. I've not been able to do it, but I will find out and get back to you on this platform. But it is something that that multiple people have told me that is currently going on right now. So next question. Hello, sir. I am on F1 visa and currently on CPT. My I-140 was approved 2 years ago under EB3, and presently my PD is currently, my priority date is current, but my employer is refusing to file my I-485 and 765 for me because I'm from one of the banned countries. Can you please advise on this? Well, one thing I want to tell you, your employer has nothing, absolutely nothing to do with your adjustment of status. For employment based, your employer is the one that will file the I-140, which is the immigrant petition for alien worker. According to you, the I-140 has already been approved. Since your I-140 has already been approved, that is the only one that involves your employer. Your employer does not have anything to do with your I-485. So if your priority date is current, on your own, you can submit application for adjustment of status, I-485. You can also submit application for employment authorization, I-765. Even though you are from a travel ban country, USCIS will still accept your application. They will still process it. They will send you fingerprinting notice and you will be on the queue. They will not approve it until the travel ban is lifted, but at least it will keep you in status. Because one thing I want employment-based applicants to know is that until the day that you apply for adjustment of status, until the day that you file your I-485, you have to be maintaining legal status every single day until your I-485 is filed. Because your employer is not the one that will file the I-485, I will just go ahead and file it myself. Like I said, the I-485 is application to register permanent resident or adjust status. It has nothing to do with your employer. You can file it on your own. The only thing you need from your employer is the copy of the I-140 approval letter. That is it. You can file the adjustment application on your own. Even if you are not from the travel ban country, your employer is not the one that will file the I-485. It is only the I-140 that the employer will file. And because that has already been filed and approved, you don't need anything else from your employer. If you have the I-140 approval letter, go ahead, complete the I-485, complete the I-765, and file it on your own. You will be okay. You don't need to include your employer's address or anything. It is your own address that is required in the application. It doesn't have anything to do with your employer. Next question, please. Good afternoon, sir. Doctor, I have appointment with USCIS interview on my I-951. My wife is threatening me that she will not go with me. What is 951?
I think it's 751.
Maybe you wanted to say 751. That's removal of condition. Okay, my wife is threatening me that she will not go with me. What can I do in this case? Well, I'm assuming that we are talking about 751, which is a petition to remove condition on residence. If that is the case, my first advice to you is that you try to reconcile with your wife. Try to work on your marriage and reconcile. The Bible says two are better than one. So if both of you are cooperating, it will be in your best interest. However, if you try your best and it is not working, then you can write a letter to USCIS and ask them to change your petition to self-petition based on good faith marriage. You tell them to change it from joint petition to self-petition based on good faith marriage. So you will need to provide evidence that at the time you enter into the marriage, your marriage was in good faith. It was not a fake marriage, but the marriage just did not work. The law does not require that a marriage must work. The law only requires that the marriage must be entered into in good faith. So you will provide evidence that at the time you enter into the marriage, you enter it in good faith. However, the marriage did not work. But you will need to provide evidence of good faith marriage, joint bank account, joint utility bills, joint lease, maybe joint trips in and outside the country, joint insurance, joint health insurance, life insurance, auto insurance, renters insurance. I mean, normal things that husband and wife do together, birth certificate of children, and all the evidence that you can gather to show that you enter into the marriage in good faith, but the marriage just didn't work. And of course, other evidence of commingling of assets, evidence that you are actually residing together, pictures, day-to-day pictures, wedding pictures. But usually, for the purpose of removal of condition, it is the evidence after you got the conditional green card. All the initial evidence that you have before the conditional green card was approved, those ones will carry minimal weight. So it is other things that you did after your conditional green card was approved. Evidence of that is the one that will be more important in this scenario. Next question, please. Good afternoon, sir. God bless you and yours. Amen. Just a minute. I have an asylum pending case. Can I do a change of status for EB2? I just finished my master's. I'm into tech and investment. I've been here for 5 years. Well, what this person didn't tell us is whether he is still maintaining legal status. And as I said before, if you are maintaining legal status for the purpose of employment base, yes, you can apply at any time. Secondly, if you are basing your legal status on the fact that you apply for asylum before the expiration of your I-94, as I said multiple times, that is something that USCIS currently disagree with. And that is what I believe. My belief is that USCIS is wrong. And that is why we have decided to challenge USCIS at the federal court. So I have filed a lawsuit against USCIS on this subject. The lawsuit was filed at the Federal District Court, Middle District of Florida. So we will keep you updated as we go with the lawsuit, but we just recently filed it. And you know, in this country, whenever you sue an agency of government, or you sue the U.S. government or an employee of the U.S. government, the lawsuit will be defended by the Attorney General of the United States. And the court, from the date of service, the court will give the Attorney General 60 days to respond to the lawsuit. So because the lawsuit was just filed this February, so I'm not even sure as of today if they have been served or not, but I will follow up. From the date of service, they will have 60 days to file a response to the lawsuit. Then we will update you as we go. But if you believe that you are in now, the adjudication of the I-1 then request that USCIS accept your application as timely. I'm sure they will accept it and approve it. But if the 30 days has expired, then you should refile it. But if you refile the adjustment application, you have to include everything that I just explained. A medical report showing the diagnosis and all the effort that you are, or all the stress. Or this is a very, very, very good question. Very, very good question, because this is one of the reasons why we have traveled out of the country. For as long as you are in the United States, your visa is useless. In the US, they don't issue visa. Visa does not determine legal status in the US. It is your I-94 that determines legal status. So even when your visa expires on 28 February, it does not have any impact on your legal status. It is your I-94 that keeps you in status. Since your I-94 is going to expire, if you decide to travel out of the US, if you travel out of the of the R1, maybe 6 months before or 3 months, if you are planning to do premium processing, you can apply for an extension of the R1. And then if this is the second exception, because R1 currently cannot be granted for more than 2.5 years. So if you still have 2.5 years, you cannot request an extension beyond 2.5 years. However, if the 2.5 years expires or is about to expire, before the 2.5 years expire, you can file a second extension request and then ask them to give you this 1 year that you stayed outside. Because you didn't work here in the US, you can actually recapture it. But you will only be able to recapture it at the end of the expiration of the second 2.5 years extension. Next question, please. Thank you. Okay. I am here in the US on J1 visa. My visa stamp. Oh, I didn't even explain what was M1. Some people may not know what is M1. For the previous question, M1 is non-academic student. F1 is academic student. M1 is non-academic vocational student. That is what is M1. Now let me go back to this question. I'm here in the US on J1 visa. My visa stamp is expiring on August 2026. My program continue till June 2027, and I wish to go to Nigeria by June 1 and be back by June 31st and renew my visa. Go back. Let me see when the visa stamp. My visa stamp is expiring on August 2026. Okay. What I'm going to tell you, except they lift the visa ban before then, you may not be able to get the extension except they lift the visa ban, because Nigeria is currently on the list of the visa ban countries. So if you are going to go to Nigeria, I will advise you, yes, you can still go to Nigeria in June and come back you can go and come back end of June. However, you may not be able to extend the J1 stamp unless the visa ban has been lifted, because currently they are going to revisit it in June. So you might want to wait and see if Nigeria will be taken off of that list before you decide to make your trip. Otherwise, if Nigeria is still on the list, you can still go and come back by the end of June and you will still be okay, since your stamp is still going to expire in August of 2026.
And then she said these are her 2 questions.
Okay. Do you think there is any concern why that's the person that has, do you think there is any concern why I shouldn't go considering the present immigration issues? Yeah, I think I already answered that. I mean, the only concern is if the country is not lifted from the visa ban, then it is not advisable to go to the embassy. You can still travel to Nigeria and come back before the expiration of your visa stamp. As I said, it is not the visa that will keep you here till 2027. It is the I-94 that you will be given when you return. That is the most important thing. But the visa is the one that will allow you to be able to go in and out of the country, not the I-94. Because the moment you step out of the country, the I-94 is useless. The moment you are inside the country, the visa is useless. So both of them have their role. The visa is useful outside the country. The I-94 is useful inside the country. What was the second question? I think there were 2 questions. You say 1. Oh, you just labeled it 1 because I didn't see 2.
No, there's no 2.
Okay.
Oh, yes, sorry.
Oh, there are 2. Okay.
Yes, there's number 2.
Okay. Do you think I can have my J1 visa renewed with the present? No, I already answered that. No, with the visa ban, no, they will not renew it with the visa ban. So it's not advisable unless the ban has been lifted. Otherwise, just go and come back before the end of it, or by the end of June, you will still be okay. Okay, next question. Good evening, sir. Well done for the good job, sir. Thank you. May the Lord continue to help you in all your work in Jesus' name. Amen. Sir, is NVC pausing on the case of the individual from 75 countries and banned countries? No. I think I answered this at the beginning. No, NVC is not pausing. They are still processing and they are still scheduling people for interview at the embassy. The only one that is not issuing visa right now are the embassies in those 75 countries. However, the embassies are still they are still working. They are still conducting document review. They are still conducting interview. They are still conducting everything. The only thing they are not doing is to issue the visa until the visa ban is lifted, except if you fall into one of the exceptions. Next question. I have a question, sir. Assuming an asylum seeker in Canada post, is it passport? Okay, assuming an asylum seeker in Canada passport submitted and has a fiancé in the US willing to file a spousal or fiancé petition, what's your advice to avoid complications? There is no complication for as long as the asylum in Canada, the pending asylum in Canada, because I'm not familiar with the way asylum work in Canada, so I don't know whether an applicant is considered legal while the application is pending. I don't know that, because what I know is that if your fiancé is a US citizen and is going to petition for you, if you are going to be interviewed in Canada at the US Embassy in Canada, you will need to show legal status in Canada. So the question to be determined, which I don't have the answer for right now, is an asylum applicant in Canada, is the person considered maintaining legal status in Canada? I don't know the answer because I'm not familiar with the Canadian law. So if an applicant for asylum in Canada is considered maintaining legal status, then yes, your USC fiancé, your US citizen fiancé can file the fiancé visa for you in Canada, and then you can attend interview in Canada. But if a pending asylum is not considered legal status in Canada, then you will not whether somebody with a pending case in Canada is considered my name to lease agreement of my wife. The housing office are requesting social security from me. Is that how is that relevant to WIC?
I don't think it is.
Okay. Now, yes, some apartment or housing managers may not want to add your name to a list if you don't have social security. That is because without a social security, they may not be able to. That is because without a social security, they may not be able to perform a comprehensive background check on you. So some apartment complex will not add your name. However, there are two ways to fix that. Number one, if they refuse to add your name to the list, you can request to be added. So if the apartment will not add your name, go back to the apartment and tell them, telling me why my wife or my husband cannot be added to my list. So if you have the letter, you can present the letter to immigration as evidence as to why your name was not included in the list. Or in the alternative, you can request to be added as an occupant to be listed as an occupant in the house. You are not going to be you are not going to be signing the list, but you will be listed as one of the occupants. Next question, please. We're warning my listeners that there is a spike is legit. It is not. A lot of information are out there that are not true. Please, this is one of them. If anyone give you information, the first thing I want you to pay attention to, if the information is coming from AI, I want you to take it with a pinch of salt. You have to be careful with it. The person who is providing this information, if this person is sure of his information, why can't the person show his face the way I'm doing now? Why do you have to hide under AI? A lot of information. There was a time that they were spreading all kinds of things. Oh, with effect from February, all dual citizens will lose their citizenship. There was a time they were saying, oh, if you have dual citizenship, you cannot use Nigerian passport to travel. All kinds of fake news. People are hiding under AI to scam people. There are a lot of scammers out there. So if anyone tells you they are doing annual verification, they want you to pay, please don't pay anybody. There is no such thing. It is fake news. Next question, please. Hello, can a Nigerian F2 status person convert to F1 status in the United States? Oh yes, you can change your status to F1. You will need to apply for a new I-20, brand new one. You cannot use the one that your spouse was using to apply. But yes, you can apply on your own. You still have to apply for admission, get your own I-20, provide your own evidence of financial ability to pay your school fees, and then apply for a change of status to F1. Yes, that is possible. We do that all the time. Next question, please.
You already answered this and this one too. Oh, okay. This lady sent the third question.
Okay, that's the person that was talking about the J1.
Yes. Can you
Oh,
repeat that?
oh yes, I already answered that question extensively. Yeah, if he's not able to renew, in fact, to be honest with you, the person who asked that question, if they don't extend, if they don't lift the ban, I will not even attempt to go to the embassy to attempt to renew the J1, because if you go to the embassy, what if they even cancel the one you have that is going to expire in August? So I will not even. So wait and see if the travel ban will be lifted. If the ban is lifted, then go ahead and apply for an extension of your visa. If the ban is not lifted, you can still go to Nigeria and come back by the end of June and you will be okay. Okay, next question. Sir, my family, including 3 biological and 3 adopted children, recently moved from Nigeria to the US on green cards. I need guidance on formalizing my adopted children's names to match our family name. Go on.
That's the only question.
That's the only question. Okay. The only thing you can do, you have to go through the court. You have only 2 options to change their name to match your family name. Option 1, you go to court here. You go to local court, district court. I don't know the state where you live, but you go to district court, apply for legal name change for them. So you file the application for legal name change. They will ask them to submit themselves for fingerprinting. So they will do a fingerprinting and do a background check and be sure that they are not changing their name because of criminal activities. And then a court can order a legal name change. That is one way of doing it. The other way of doing it is to wait until you apply for citizenship. When you apply for citizenship, you will have the option to change your name legally. So there is a question in the application for citizenship that will ask you, do you want to legally change your name? You just say yes to their own application, and then they will change it for you. But if you don't want to wait until citizenship, you can just go through the court and apply for legal name change. That is the only way to change it. Next question. Good day, sir. My M1 visa expires on the 28th of February, but I answered this question already. Yeah, I answered this question already.
Maybe she sent it twice.
Yeah, that's the one that I said. I even went back to explain what is M1.
Okay, this one.
Okay. Good afternoon, sir. What's the time now? Oh, it's already 1:33, so we should be preparing to. Yeah. Good afternoon, sir. Please, do you know how long USCIS FOIA take? Well, I don't think this should be affected by pause. FOIA could take anywhere between 30 days and in some cases up to 1 year. So it depends on the person asking for the FOIA. If the case is electronic, FOIA takes a very, very short period. You could get it within 2 weeks. But if it is paper, if it is paper filings, because paper filings require the applicant may have multiple files in multiple locations. For example, somebody who applied for H1B, for example, they are going to have a file at the service center. If this person subsequently apply for another form of relief, maybe apply for asylum, they are going to have a file in an asylum office. So if this person is doing a FOIA, if all these applications are in paper form, FOIA is going to take a lot of time. Number one, they will need to bring all the files together. Then when they bring all the files together, they will need to scan it before they can respond to the FOIA. But if this is a recent case where everything is electronic, FOIA is very, very fast. It could be anywhere within 2 weeks and 30 days. But if it is paper form, it could take up to 1 year. Next one. Good day, doctor. I got my 10-year green card May 2025 via VAWA. An ASC code 5 appointment was sent to my estranged wife's address instead of my attorney, which I believe was a mistake. What should I do? Well, maybe you didn't withdraw. I mean, I'm just guessing now because I really don't know the exact details, but I'm suspecting that this is probably a situation where somebody filed a petition on your behalf. Maybe the petition was either denied or the petition was pending, and then you decide to apply for VAWA. So it may be that USCIS is revisiting the initial application, and of course, whatever address they have on file is what they will do. So in this case, I will just contact USCIS and find out the need for application, for the need for fingerprinting in the first place. Because if you already have your green card, I don't see any need for it. It may just be a mistake. So you may just disregard it or just contact USCIS to ensure that they have your updated address. That's all I will say. But it's probably a mistake. But it may also be because I said previously that they are reviewing VAWA cases. It may also be that they are conducting investigations. So I really don't know the details in this case, but all the different scenarios that I can think of is what I just told you. But if I were you, I would just disregard it because you already have your permanent residence card. If immigration really wanted anything from you, if you don't respond to that initial one, they will go back to your file, look at the address and realize that you have a new application, you have a new address, and then contact you. So I would just disregard it if I'm in your shoes. Good day, Dr. Asekun. Thanks for all you do. Thank you. Okay. Let me know when we are getting to because it's already 1:37.
When do you want to stop? Because we still have a lot to go.
Yeah, this is the second hour. We've been on it for over 1.5 hours now. So maybe another 5 questions.
Okay.
Yeah, one of two. Good morning, doctor. Please help out on this situation. Wife, U.S. citizen, file for husband. He just got extension on his 2-year green card. Okay, where is 2? Okay, he visited wife who works in another state and met another man in the house. Okay, go back. Let me go back to 1. I want to see who is the U.S. citizen. Wife, okay, wife is the U.S. citizen. Okay, and file for the husband. Okay, he visited wife who works in another state and met another man in the house. Okay, wife is angry and has initiated a divorce because husband visited without informing her. Can the husband do I-751 alone? He has an extension already. Yes, I think I've answered a question that is that okay? The stepchild is refusing to move over to mom's place. The child is 17. She has been living with the husband for 5 years. How can this be handled? Thank you, sir. Well, the poor boy should not be, or I don't even know whether it's a boy or girl. Yeah, the poor child should not be dragged into this. What I will say here is that based on this fact, personally, I want to believe that this is a legitimate marriage, because if it is not, the stepchild will not be living with the husband. So I want to believe this is a legitimate marriage. What I will advise you, try to work on your marriage. But if the marriage fails, if the wife files for divorce, yes, write a letter to USCIS, request them that they change your petition, that your 751 that is currently pending, ask them to change it from joint petition to self-petition based on good faith marriage. Write a very detailed letter explaining the situation, explaining what happened between you and your wife. You will be okay. But like I said, as far as the boy is concerned, it is possible to not marry the mother and still have a relationship with the guy, with the child. So I think you should handle the issue of the child more carefully. You don't. It's a very dangerous thing. One thing personally that I like to avoid is to avoid doing something that will hurt a child, because a child has a future. You have no idea how this child is going to end up in life. You don't know what this child is going to become in the future. You may not know. This child may be future American president. You may not know. This child may be someone important in the future. So I want to maintain good relationship with the child, irrespective of what the mother did. After all, this woman was your wife, or is still your wife. So try to manage the situation. You don't have to force the boy out. If the mother is the one filing for divorce, I'm sure she will make arrangements as to where her own child will live. But if she decides to leave the child with you, if I'm in your shoes, I'm not going to make a big deal out of it. At least let the child not be part of the divorce. Next question, please. Like I said, 5 more, and then we stop for today. Sir, after application is work authorization still issued for partially and fully banned countries? Thank you, sir. Oh, is work authorization still issued? I believe that is the question. Well, that's the way I can understand it, that after applying, is work authorization still issued for, if you are, that's what I can translate the question to mean. And I think I answered it before. We just noticed that we have not been receiving work authorization for clients from travel ban countries. I didn't notice it in our office until yesterday, when somebody whose employment authorization was approved in December, and up till now we have not received it. And then the person asked me the question, have we been receiving employment authorization for applicants from travel ban countries? That's when we started checking and now realize that all the ones we have been receiving are from countries that were not affected. So I don't think they have been sending it, but that is just based entirely on what we have observed in our office. Next question. There should be 4 more left. Okay. I have 10-year green card, which was approved after 2 years of my marriage. I received a reminder notice from USCIS to remove condition on my green card. Is this not an error or I should file 751? Well, if you already have 10 years, it's an error, so you don't need to file 751. So just disregard it. Next question. Thank you so much, sir, for all you do. Thank you. God bless you. Amen. Can I apply for premium processing for a pending I-140 application? I'm from a partially banned country. Oh, yes. Well, that's a technical issue right now because what is the point of wasting the money if they are not going to take a decision? Because for travel ban countries right now, they are not taking decisions. So if you apply for premium processing, I don't think it will.
Unless she wants to have the assurance that it's been approved.
What if they don't approve it? Because the travel ban says they should pause this and not take a decision. So they are not going to take a decision. So it's just going to be a waste of money. So I will not waste my money. I mean, based on what we have seen, they are not going to approve or deny it for now. So what's the point? It's not cheap. So I would rather wait. If the travel ban is lifted, then I can still apply for premium processing if the I-140 is still pending. But for now, it's just going to be a waste of money because they will not take any decision right now. Next question. So it should be 3 more now.
Yes.
I'm about to do marriage-based petition. My age declaration carries my real father's name. Do you think this will cause a problem? Thank you, sir. Is that a prior question?
No.
So, I mean,
That's the only question.
why is he talking about real father? Is there a fake father? Is there, are you sure there are no other questions? I'm about to do marriage-based petition. My age declaration carries my real father's name. Do you think this will cause a problem?
Maybe her maiden name. No? Like from her biological dad's.
Well, first and foremost, immigration will not even accept age declaration. That is the starting point. So whether your age declaration carries your father's name or somebody else's name, it is immaterial. Immigration will not accept age declaration for people from Nigeria. You will need to obtain attestation of birth from National Population Commission. That is what you need. If you don't have a birth certificate, you will need attestation of birth from National Population Commission. And of course, if your attestation of birth has your maiden name, there is nothing wrong with it, if that is your question. But immigration will not even accept age declaration. They stopped accepting that almost 10 years now. So you have to obtain attestation of birth from National Population Commission. Okay, there should be 2 more. Okay, I'm on R1 visa, but with this backlog on EB3, can I go to nursing school while still on R1, or do I have to switch to F1? And can R2 still apply for visa in Nigeria despite the ban? Well, the last question first. No, the ban will affect R2 visa in Nigeria. Then going back to the first one, you cannot go to nursing school on R1. No, you cannot. R1 is a non-immigrant status. Non-immigrant, you are supposed to be a non-immigrant religious worker. You are not allowed to go to school on R1. Incidentally, R2 can go to school, but R1 cannot. R1 is supposed to work exclusively for the church. But if you have a dependent, let's say you have a wife who is on R2, your R2 can go to school, can go to nursing school, can do anything, but you on R1, you cannot. So if you need to go back to school, you will need to change from R1 to F1. Okay, it should be one more. Okay, thank you, doctor. I have an initial 3-year H1B visa with expiry date February 7, 2026, 2 years, instead of 2/7/2027, but with petition expiry date of 2/7/26. Yeah, that is why they approve it till 2/7. If the petition is valid till 2/7, your I-94 will also be your visa or your I-94 will also show 2/7 because they can't approve you beyond the petition. Okay, what is the question? Perhaps due on my Nigerian passport expire 5/5. What do I do? No, I didn't get the question. Let me read it again, please. Okay. I have an initial 3-year H1B visa with expiry date 2/7/2026, 2 years instead of 2/7/2027. But petition expiry date of 2/7/2026. Perhaps due to my Nigerian passport expire 5/5/26. What do I do? Okay. Okay, before I go into, is it part of the question? Before I go into the second question, when they apply for the H1B, they will have submitted LCA, labor condition application. Usually, immigration will not approve it beyond the date on the LCA. So I'm sure the date on the LCA was probably 2/7/26. That was why they approve it till 2/7/26. Even though H1B is valid for 3 years, they will not approve it beyond the period that is stated on the labor condition application. So that is one. Then question 2. Are you... Oh. Okay. Also, my I-94 shows 2/7/26 expiry date, but my spouse with H4 has 2/7/27 as the expiry date on her I-94. Do I send my renewed Nigerian passport for the expiry date correction? No, you will need to file a new petition extending it. And I hope you are not already out of status because today is already 2/18. So if this thing expires 2/7/26, you need to apply for an extension of the H1B. This is not affected by the quota. This is not one of the lottery thing since you already have H1B. But if you go back and look at your labor condition application, because H1B we always commence at the beginning of the year and the effective date is towards the end of the year. Effective date is usually October 1st and the petition may have been filed sometimes in March. So I'm sure that the labor condition application is the one that led to the approval of the petition that stated 2/7/26 because USCIS will not approve the petition beyond the date that is stated on the labor condition application. So you need to apply for an extension of the H1B. That is all I will say. So that should be is that the last one or that should be the last now?
No, I think this is the 5th question.
Okay, yeah, let me just answer the last one and then we close for the day. Okay, are we supposed to pay for green card printout for each immigrant that comes in?
Yes. The production of the green card.
Oh, are you talking about production of the green card? Oh, yes. Everyone that obtained immigrant visa, yes, you need to pay for the green card processing. I think it's $220 each.
It's $235.
Okay, $235. Oh, they increased it. It used to be $220. Okay, it's $235 each. Yes, everyone coming in with an immigrant visa, they need to pay for green card processing fee. If you don't, you you will not receive the green card. So the earlier you pay it, the better. What is this news? Something about news. Move it up a little. Can you please clarify the news about car registration only for citizens?
Yeah, I saw
What does
that.
that mean?
So in Texas, you will only be able to register a car if you can show legal status.
Yeah, but that doesn't mean citizenship. That doesn't mean citizen.
Well, it's passport, birth certificate, or if you come from abroad, passport and visa.
Where did you see that? I've not come across that.
I'll show it to you. Yeah, it came out yesterday.
Well, that's going to be the last question for today, but I just saw car registration. I've not come across that. But so what about people who are on non-immigrant status? F1, H1B, R1.
Can show their legal status visa.
So apparently it's not limited to citizens.
No.
Okay. So from what I had now, I mean, like I said, I've not had it personally, but from what I had now, you are required to have legal status in Texas. This is a Texas thing, it's not national.
It's Texas.
This is a
The Texas Department of Motor Vehicles.
okay, this is only in Texas that you need to have legal status in order to register a vehicle. So that is only in Texas. You don't necessarily have to be a citizen. You just need to show legal status. Well, we will have to round up today. It's almost 2 hours now. I thought I would finish before 2 hours. It's already 1 hour, 54 minutes. So it's almost 2 hours. So we'll have to round up today. We will continue again next week by God's grace. Remember to always invite your family, friends to join us every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern. That is 10 a.m. Pacific. That is currently 7 p.m. Nigerian time. Wherever you are watching us, we encourage you to also join us on all our other social medias, Facebook, Instagram, X, TikTok,
Yes.
and YouTube.
Let them subscribe.
And of course, subscribe to our channel so that whenever we go live, you get notified. So until next week, we hope to see you again. I remain yours sincerely, Dr. Olu Asekun. Please stay out of trouble and take care of yourself. This time will pass. We will enjoy the fruit of this nation by God's grace. See you next week by God's grace.